Now, we've talked about the duty. What is the standard of care? We've all got a duty, but exactly what does that mean? Well, interestingly enough, in our society, laws can often specify what the standard of care is. In other words, what specific kind of conduct should I engage in or refrain from doing that is going to specify the duty of care. For example, speeding. If the speed limit is 55 miles an hour and I'm going 90, clearly I'm violating the standard of care that's been set for what should happen on that particular stretch of highway. So statutes and regulations can set a duty of care. In the occupational area, the Occupational Safety and Health Administration, OSHA, through its regulations and through the OSHA statute, which authorized the creation of that agency, those OSHA regulations specify in great detail often a duty of care. The statute itself mandates what's called the general duty, and that's basically for each employer to provide a workplace that's free from recognized hazards. So I'll just say it again. Each employer has a general duty under the OSHA statute to create and maintain a workplace that is free from recognized hazards. And the issue is recognized. If the hazard isn't recognized, there's no duty that arises. If for example, there's no standard, no recognized hazard for having open bags of marshmallows in the workplace, then if somebody gets hurt by over ingesting marshmallows, that's not going to be a violation of the general duty. That's somebody's messing around too much with marshmallows. But when we're talking about free from recognized harm, you focus on the recognized. Now, as I said, OSHA promulgates regulations that are very specific. Construction standards will tell you how much strength a ladder must have in order to bear or to be used for certain functions. There are specifications and regulations that tell us what kinds of scaffolding must be used on certain kinds of operations. If you're digging a trench, there are certain requirements that must be met in order to assure that people don't get crushed to death when, for example, a trench is being dug and some rain comes along and all of a sudden everything falls in. Before OSHA, there were a lot more industrial accidents in all kinds of industries. OSHA has really changed the landscape by setting what in tort law we call very specific standards of care, what OSHA calls regulations that specify the duties. Even apart from the OSHA regulations or statutory things, you might have industry standards. There might be in a particular industry, and bear in mind that the people who operate those industrial companies are presumed to have a level of expertise by virtue of the fact that they are able to design, invent, create the industrial processes. They are presumed to have an expertise about what is safe and what is not safe about the processes that they've created. So there may be industry standards even apart from the OSHA standards. Bear in mind that if in a particular industry or a particular situation the industry standard is more rigid than the OSHA standard, then when we're talking about a lawsuit, when we're talking about a standard of care, the higher standard will apply. The higher standard will apply, not the more lax standard. The expertise of the person who's acting. If I am an expert in how to pour molten brass in a foundry, if I'm the recognized expert in that, my expertise in one sense will be held against me because to the degree that I'm an expert, if I behave negligent, if I behave contrary to what I understand to be safe practices, my own expertise can be a standard of care. Publish professional standards. Many of the professions publish books that specify what is and what is not safe in the practice of that profession, and those become standards of care. Think about what happens in the medical profession. The standard that of the the level of competency that is expected in a particular community. So in a small community, very small community that has unsophisticated medical practices, perhaps not much in the way of a hospital available, the standard of care in medical malpractice suits tends to be local. So they look at what is the level of care that you could expect in your locality. If you're in New York City or Philadelphia or Charlotte, where there is some kind of major healthcare facility, and you've got super experts in all kinds of medical practices, that standard will be relevant. Okay, so that's a fairly exhaustive description of the standard of care, but it's important that you bear that in mind, because you can't, in essence, claim ignorance of the standard of care if it's something that you are knowledgeable about or should be knowledgeable about. Okay, the question then becomes whether the defendant acted unreasonably by maintaining an unsafe condition, or by behaving in a certain way that causes injury. Was the individual behaving reasonably? Because that's part of the standard, and that's evaluated against the notion of what a reasonably prudent person would do in the same circumstances. And we're going to get back into this notion of what it is reasonable to do. Because for all of us as people responsible for the safety of students in our classrooms or our internships or on our field trips, the question will always be, did we behave reasonably under the circumstances?